Arbitrators, and also to our sponsoring partners today, to DB Voice and Plimpton as our partner, and to Tanzer as our general partner. Just not to spend too much time, now I give the floor to Alexandra Anufrieva. Alexandra Anufrieva is a moderator of the first session and is a partner at Just. Thank you very much, and I give the floor to you, Alexandra, and enjoy the conference today.
Julia, thank you. Thank you for the introduction. Thank you for the invitation to moderate this session. And everyone, welcome to the conference. I hope it will be an insightful event and thought-provoking, especially for the competitors of the moot court. I know that they are among the audience. And today on my way to office, actually, I was stuck in a traffic jam, which is unexpected. It's just the day that I'm out of the lockdown and the country is just less than a week trying to be back to the normal life after several months of being closed at home. And I thought that it's kind of a good sign that my new free non-lockdown life starts with this conference. And on the other hand, it's actually exactly very, 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 very good that we can still have these kind of events, even in these strange lockdown times. And very big thank you for the organizers to make it happen. Let's start with the actual first panel. We will be discussing several topics, and we will start with more broad ones related to substantive matters. We will discuss the issues of succession in international succession of states and the issues of state responsibility. We'll be discussing the disputed territories and applicability of treaties, territorial application of treaties in disputed territories. Then we'll move on to the arbitration involving multiple parties, and then back to the issues of state responsibility. So I would suggest that we start the panel, and I'm pleased to invite Dr. Catherine Titi to kickstart the session with the discussion on the issues of succession and responsibility. Catherine.
Thank you very much, Alexandra. I would like to also thank the Russian Institute of Modern Arbitration for this kind invitation. It is a pleasure to be here, even if it is online and not in person. So I'm going to discuss state succession and international responsibility. For many years, the succession of states to international responsibility has been a thorny issue that even the International Law Commission has avoided dealing with in the past. As we will see, this has now, of course, changed. The taxing issue is whether there is a succession of states to obligations of reparation when a predecessor state has committed an internationally wrongful act before the actual succession took place. The 1978 Vienna Convention on Succession of States in respect of treaties and the 1983 Vienna Convention on Succession of States in respect of state property offer a definition of state succession. Accordingly, succession of states means the replacement of one state by another in the responsibility for the international relations of territory. Both conventions apply only to succession of states taking place in conformity with international law, so not to unlawful successions. In short, the question is to know whether there is succession to responsibility, and this is the topic that I will be discussing in the time that I have. The ILC commentary to Article 11 of the ILC Articles on the Responsibility of States for International Wrongful Acts expresses this uncertainty by stating that in the context of state succession, it is unclear whether a new state succeeds to any state responsibility of the predecessor state with respect to its territory. One reason why it has been so difficult definitive answer to the question is that state succession is not a phenomenon. Therefore, there is no clear, or there is certainly no ample authority. There is no extensive state practice. And state practice in this area has been described as diverse, context-specific, and certainly sensitive. Now, in May 2017, the International Law Commission decided to place the issue on its current work program, and it appointed Professor Pavel Sturma as special rapporteur. So far, the special rapporteur has issued 3 reports with draft articles. So maybe in the near future, we are going to see some ILC articles on state succession and international responsibility. So how has the issue been dealt with so far? In the past, the predominant answer has been that there is no succession to state responsibility, what James Crawford has called the negative succession rule. In fact, this non-succession rule or negative succession rule comes to us from 2 early arbitration cases. The 1923 Brown case concerning the annexation of the Boer Republic of South Africa by Great Britain, and the 1925 Hawaiian claims case concerning the annexation of Hawaii by the United States. However, law is not stable, but as we know, it always evolves, and a more nuanced view appears to be emerging, according to which the answer cannot be given in the abstract, but it depends on the facts of each particular succession. One of the arguments that underpins the traditional negative succession rule is that only states that have committed an internationally wrongful act should be held responsible for it. In reality, however, succession to responsibility really means succession to the obligation to make reparation. In other words, it is not a question of finger pointing. It is not a question of attributing actual responsibility for an internationally wrongful act to a state that has not really committed it, but rather to inquire into whether an obligation to remedy such an international wrong exists. In this respect, Article 1 of the ILC Articles on the Responsibility of States makes it clear that every internationally wrongful act entails the international responsibility of a state. This is an objective test. It is not linked to a mens rea. There is no element of culpability. In other words, it is not a case of accusing a state, rather of making sure there is reparation for an international wrong. Now, another argument that has been used in favor of the negative succession rule is that internationally wrongful acts are of personal character. This is a notion that comes to us from Roman law, where liability for a delict did not pass to an heir. This private law analogy is generally rejected in legal scholarship, and anyway, the rule does not necessarily even survive in contemporary legal systems. The negative succession rule started to be qualified and rejected, always depending on the case. We owe the beginning of this development, this evolution, to the 1956 Lighthouse arbitration. So what is the status quo now? We need to distinguish between different types of state succession. There is no global answer to be given that covers every situation. And broadly speaking, we have 2 categories of state succession. On the one hand, we have cases of state succession where the predecessor state continues to exist. And on the other hand, we have cases of state succession where the predecessor state no longer exists. So I'll start by discussing the cases of succession where the predecessor state continues to exist. So first, in this category, we have secession. And secession is a situation where a new state, which we call the successor state, emerges from the breakup of an already existing state, which at the same time continues to exist, although it has lost part of its territory. So secession is a separation of parts of a state. In cases of succession where the predecessor state continues to exist, the general rule is one of non-succession to responsibility. But we have exceptions. For example, a state may agree, rather there may be an agreement, a treaty, where the successor state assumes responsibility. There may be a unilateral declaration whereby a successor state accepts responsibility. Further exceptions have emerged in the literature, including in a 2015 resolution of the Institute of International Law, and this was recognized in the ILC Special Rapporteur's second report. And these exceptions are the following three additional exceptions. First, internationally wrongful acts committed by an autonomous entity if we have internationally wrongful acts that have been committed by an autonomous entity of the predecessor state. An example of this situation would be devolution of powers to local authorities. This devolution must be clear, of course. Then the second exception is a link between the internationally wrongful act and the territory. We're not just discussing a situation where the in the territory of the successor state, but we need to look at a closer link between the wrongful act and the state and the territory. Finally, we have the question of unjust enrichment. So an exception when the successor state would unjustly enrich itself as a result of an internationally wrongful act that was committed before the date of succession. So this was the first category of succession where we have secession. And then we have a second category, responsibility for the conduct of insurrectional or other movement. So an exception to the general rule of non-succession relates to the responsibility of a new state for the conduct of an insurrectional or other movement. And in this respect, I would like to draw your attention to Article 10 of the ILC Articles on State Responsibility, which provides as follows. In paragraph 2, the conduct of a movement, insurrectional or other, which succeeds in establishing a new state in part of the territory of a pre-existing state or in a territory under its administration, shall be considered an act of the new state under international law. So in this case, the successor state is the one that is going to bear responsibility. A third category is that of newly independent states. This relates notably to situations where there had been colonial rule or protectorates. Here too, the general rule is one of non-succession. It is generally established that the predecessor state, so the colonial or protecting power, which continues its existence, assumes responsibility for its internationally wrongful acts that were committed before the date of succession. And then we have transfer, a fourth category of succession, where we have cession, which means we have a transfer of part of the territory of a state. This category includes a broad range of situations where part of a state's territory is voluntarily transferred by one state to another state. In this case, the predecessor state continues to exist, of course, but also the successor state existed at the time of the succession. In this case, too, responsibility lies with the predecessor state, and the general principle of non-succession applies. Here, possibly more than in other situations, I'm saying this with a little doubt, this often happens by agreement. I mean, we can have agreement in many situations, acceptance of responsibility. I will give you an example. So when in 1947, Italy ceded the Dodecanesian Islands to Greece, it agreed that it was to compensate victims of expropriations that were committed during the period when Italy exercised control over the island. So this was in the peace treaty, and this was an example of acceptance of responsibility by agreement. And now I move to the second category of succession, cases of succession where the predecessor state no longer exists. Here, the first subcategory is the unification of states, or, which is to say the same thing, extinction by merger. Unification of states which is the term used by the ILA by the ILC Special Rapporteur, refers to the situation where two or more states unite to form one successor state. The successor state assumes the obligations of the predecessor state for internationally wrongful acts that were committed prior to the succession. The second subcategory is that of incorporation of a state into another existing state. So this is a case of voluntary absorption. And the obvious example here is the reunification of Germany. And interestingly, we have some case law from the Federal Administrative Court in Germany, which held that the Federal Republic of Germany, so the successor state, could not be held responsible for internationally wrongful acts committed by the GDR. However, it considered that the Federal Republic of Germany had the obligation to compensate. Then we have a third category, a third subcategory, which is that of the dissolution of a state, whether it is voluntary or involuntary. An example of a voluntary dissolution is that of Czechoslovakia, an example of an involuntary dissolution, that of Yugoslavia. So in dissolution, a predecessor state dissolves and no longer exists, while the parts of its territory form two or more states. Here, the negative succession rule does not in principle apply. That does not mean that there is an automatic succession to obligations arising from the responsibility of the predecessor state to all new states. And in this respect, the RLC Special Rapporteur has stressed that there is a presumption that obligations pass from the predecessor state to the successor state or states, but he also highlighted the importance of agreements. A further issue of relevance, which is examined by the ILC and forms the object of the third report of the Special Rapporteur, is the issue of reparation for injury resulting from internationally wrongful acts committed against the predecessor state. So this is not a topic I'm going to go into, but I think it's also interesting to bear this in mind. In conclusion, it is preferable to have an approach that is fact-based. It is preferable in any case in decision-making to have a look at the particular case and not to have general solutions, tailor-made solutions. And in the context of succession in the responsibility, a succession to responsibility in case of state succession. In cases where the predecessor state is still extant, the successor state will be less likely to assume responsibility. By contrast, in cases where the successor state no longer exists, there is an increasing assumption that there is succession to responsibility subject to the particular circumstances of the case. Thank you very much for your attention.
Catherine, thank you. Thank you for discussing the state of art in this field. I've got a question. I don't see any from the audience so far, but I've got a question which is kind of a bit of a step aside from the issue of succession, but this is still about the state responsibility. What is your opinion? What would you say? What do you think about a standpoint which is voiced every now and then? At least I came across it several times. That actually the draft articles on state responsibility of states for the wrongful acts, and it is a common point to apply these draft articles and to refer to these draft articles in the decisions of investment arbitral tribunals. But still, there are some people who would say that it's kind of a common error to apply the rules which were initially aimed to the situations of state responsibility vis-a-vis another state to the situations when we have an individual on the other side. what would you think? What would you think? What would you say in this regard? Do you think this can be a viable point of argument, maybe for the respondent state, or maybe when it comes to quantifying the responsibility of in any other situation?
Thank you, Alexandra. For one thing, I'll start by saying, of course, it depends again on the particular case. I mean, something that we need to remember is that the ILC articles on the responsibility of states are meant to codify customary international law, but there is also some ambiguity. There is some so when the ILC articles on state responsibility were being elaborated, or maybe even before, there was this question of whether they should the states should sign a convention, whether it should be a convention, and the idea was withdrawn because there was this assumption that there would not be enough support to actually draft a convention and convince states to sign it. There are some cases where we have seen in investment arbitration very limited interpretations of the ILC articles. One example that I have in mind is in some of the Argentine crisis tribunals, when the tribunals were looking at the necessity defense. So the necessity defense has this condition. It says that it must be the only situation for a state to deal with a wrong, with a necessity. There was one tribunal that said there are always other situations. Well, if there are always other situations, that means Article 25 on necessity never applies. What I'm trying to say is that maybe the phrasing of some of the ILC articles, you know, I'm not going to say that, I'm not saying they don't reflect customary international law, but we must keep in mind that this is not a convention. It is meant to codify customary international law. It is not necessarily itself customary international law. So there's a distinction to be made. But then on the other hand, I think by analogy, we can apply to come back to your question, we can apply the ILC articles by analogy, especially if it comes to discussing a wrong committed by a private entity. So if you can use this against the state, which is the major entity, you can, I think, also use it against a private entity.
Okay, yeah, thank you very much. If someone from the panel would like to speak on this issue, you're very welcome. But if not, then maybe I will readdress this and raise this issue again later on when we come to the issues of state responsibility again. And for now, we will then move on, and I would invite Olga Hamama to start with her topic, the territorial application of treaties in disputed territories. Olga, the floor is yours, and yeah, I already see your presentation.
Perfect. Thank you very much, Alexandra. Thank you very much, Catherine. To start with, thank you very much for the invitation. It's a pleasure to be speaking here today. Thank you very much for the audience listening to us and to all the Mooties. Congratulations, they made it quite far. I'm based in Frankfurt, so in a city where unfortunately most of you are not going to be able to be this year, but I very much hope that physical presence will be possible in the years to come. So my topic today is the topic of the territorial applicability of treaties in disputed territories. It is good because I can build up on a couple of notions which have been introduced and mentioned by Catherine already. So just a second. We tried everything worked, but for some reason at the moment my slides are not working now. Now it's working, very sorry. The purpose of the presentation, or my intention, is not to cover obviously all possible issues relating to territorial application of treaties when it comes to territorial disputes, but to give an idea and pinpoint some of the specific legal questions and problems that might arise in such situations, and also shed some light on some specific cases, case law, which might provide for some clarity and solutions in such cases. So if we think about the territorial disputes worldwide, in fact, there is a great number of territorial disagreements and disputes going on global scales. So in general, such disputes might refer to border disagreements, unrecognized or self-declared states, or partial territories within sovereign states. They might concern disputed islands, maritime boundaries, and self-governing territories, annexed territories, and lands. In general, the problems arise because there is no consensus between two or even sometimes more states, but mostly two states affected and involved in these situations, and also the lack of the international recognition of the legal status of such territories that are disputed. So the starting point when we talk about the territorial application of treaties is customary international law. And as Catherine mentioned already, some principles of customary international law have been codified, and one of such examples is Article 29 of the Vienna Convention on the Law of the Treaties. Article 29 regulates territorial scope of treaties and states that unless different intention appears from the treaty or is otherwise established, a treaty is binding upon each party in respect of its entire territory. In other guidance with regards to the territorial application can be found in Article 15 of the Vienna Convention on Secession of States in respect of treaties. This article, on the other hand, on the one hand, regulates the succession of treaties of predecessor states and successor states, and regulates that, this regulation applies unless it appears from the treaty or is otherwise established that the application of the treaty to that territory would be incompatible with the object and purpose of the treaty, or would radically change the conditions of its operation. So the limitation here seems to be broader than the one which is comprised in Article 29, which we've seen before. But the actual problems arise, of course, in practice when we are dealing with situations of so-called de jure and de facto situations. So as I mentioned previously, in most of the situation, we will be facing the situation when one of the states involved in the conflict is not going to recognize, for example, sovereignty of the territory which might have been occupied or annexed, for example, or is disputed by the other state. And if such recognition is also not followed by the international community, we might be facing in such situation the fact that a sovereignty and potentially also territorial application of treaties might be problematic in light of international law. So what are the next steps or points one should pay specific attention to? Well, one of the starting points is the consideration that the notion and the term of territory as such is not defined in the treaties previously mentioned. And a look into the commentaries to the treaties suggests that extraterritorial application might be falling outside of the scope of Article 29 of the Vienna Convention on the Law of the Treaties, for example. On the other hand, Article 6 of the Vienna Convention on the Secession of treaties of states in respect of treaties contains a so-called called blanket limitation clause and provides that convention applies only to the effects of a succession of states occurring in conformity with international law, and in particular the principles of international law embodied in the Charter of the United Nations. Accordingly, we might be facing difficulties if a sovereignty of and succession of the respective territory is not recognized by the international community and is not valid under international law. In addition, difficulties might arise when definition of territory, depending on the definition, in fact, territory in bilateral or multilateral treaties. In general, it should be said that on one hand, the notion of treaty can define the geographical application of the treaty. On the other hand, we might be dealing with treaties which application as such might be triggered by a definition of the specific territory or application in the specific territory as such. In addition, I've mentioned already that there is no explicit regulation of the extraterritorial application of Articles 29 and Article 15, respectively. And although the commentaries suggest that it falls outside of the scope, at least of Article 29 of the Vienna Convention on the Law of the Treaties, the question arises as well whether application of the customary equivalent of the so-called moving treaty frontier regulation is possible, and whether application to the territories that a state controls or over which it claims sovereignty is possible despite the fact that such control or claim might not be valid or might be unlawful. What are the real-life implications of such problems? Like when faced with international investment arbitration proceedings or arbitration proceedings in general, obviously possible jurisdictional objections might arise in these specific situations. Respondents, for example, might argue non-application of the respective treaties to the disputed territories. In general, this position is possible, but is likely to be inconsistent with the claim to the territory of the respondent states. Again, not excluded though as an argument. The parties might also argue that a decision on the territorial dispute as such might be necessary, and that's why in investment treaty arbitrations, if the arbitral tribunal were to accept jurisdiction, it would exceed actually the scope of its jurisdiction under an investment treaty. The questions of the application with regards to the timing of these specific treaties might arise, and those arguments are mostly very fact-specific and deal with the, differentiate between the specific actions of the states and the alleged infringements. Of course, the question of the extraterritorial application of investment treaties and the arguments that this is not provided for in the treaties in the specific circumstances might be argued as well. So what I would like to do now is to present some of possible arguments or present a couple of selected cases which hopefully will help and shed some light on these problems or selected questions with regard to the application of moving treaty frontier rules under customary international law. So the first case I would like to mention here is the case of Sanom Investments Limited against the government of the Lao People's Democratic Republic. It is an investment arbitration case which has been brought by an investor incorporated in Macau. Well, now Macau was administered by Portugal and People's Republic of, and was then lawfully, sorry, just a second. For some reasons, internet is not up to speed today. Well, then it was. Again, it was a lawful succession in that case, but nonetheless, the case provides some fruitful guidance with regard to the questions posed before. So on the one hand, the tribunal confirmed that Articles 29 of the Vienna Convention on Law of the Treaties and Article 15 of the Vienna Convention on the states succession with regards to treaty are rules of customary international law. On the other hand, the tribunal confirmed that principles of the territorial extension under Article 29 applied unless otherwise indicated, as we've seen before, and also confirmed that the moving treaty frontiers regulation was a pre-existing customary law. So it can be a point of resort, even if one should decide that Articles 29 and 15 are not applicable directly. The case was, or the subject matter of the case was also at the core of a decision of the High Court of Singapore in the case brought by the government of the Lao People's Republic versus the investor, against the investor. And in this case, the court evaluated new evidence and decided that, well, specifically two governmental letters that have been exchanged, and referred while interpreting these letters in accordance with Article 31 of the Vienna Convention on Law of the Treaties, and decided that the protection, the BAT protection, didn't extend to Macau, and therefore investor was not protected as well. So what is important well, in this specific case? Well, first of all, the confirmation that the moving treaty frontier rule was recognized as a customary international law, and secondly, also that it's possible that territorial application can be modified by an agreement of the parties. So in other, no, apologies. So in other aspects, I would like to bring our possible arguments which are brought in the context of object and purpose of the treaties. In this context, one could see different arguments, and some of them are stating that treaties, there are two different types of treaties. Some treaties are aiming at governing state conduct generally, for example, mostly in this context, human rights treaties, or sometimes treaties for environmental protections are mentioned. And such treaties are protecting individuals against improper conduct by states, and therefore are not limited by the territorial application as such. On the other hand, there is an argument that some treaties are aiming at governing states' conduct within a specific territory, and this specific category is different from the first one, and this difference should be also considered when reviewing specific cases. So in this context, it's interesting to mention an ICJ case where the International Court of Justice dealt with legal consequences of the construction of a wall in the occupied Palestine. In that specific case, the question arose with regards to the application of the International Covenant on Economic, Social, and cultural aspects. And the court mentioned that it doesn't contain any specific provision on the scope of the application of the treaty. However, the court also mentioned that this does not exclude the possibility of the treaties to be applicable both to the territories over which a state party has sovereignty and to those territories over which that state exercises territorial jurisdiction, factually. So the ICJ also stated that a state could, in certain circumstances, be under obligation to the rights under the treaties in occupied territory. In these specific circumstances, one should, however, pay attention to the type of individual rights in question, as well as the character of the obligations it created for the parties. Another aspect I would like to mention, wrapping up my presentation, is the question of the extraterritorial application of treaties as a result of specific provisions included in the treaties. So in some treaties, we can find specific language defining the concept of territory or referring to definitions or like specific types of territories. This is the case in many bilateral investment treaties, which quite often refer to a specific geographical scope or sovereign territory in their language. Some treaties are even more strict, and those examples are mostly double taxation treaties because they can refer to sovereign territories, but also to specific sovereign rights and other rights, sovereign rights, in compliance with international law. This is just an example of just picking on the model, Germany's model BAT, where you can see that in bilateral investment treaties, quite often territory is addressed in various articles of the treaties, inter alia, while defining investment in the specific territory of a contracting state. So finally, I would also like to mention in this context the possibility of reference to jurisdiction of a state. So in some treaties, we will not find a reference to territory as such, however, to the notion of jurisdiction, which will also provide us with an opportunity to define the geographical application of treaties. So in one of the cases dealt with by the European Court of Human Rights, the European Court of Human Rights, considering Article 1 of the European Convention of Human Rights, stated that jurisdiction under this provision is not restricted to national territory of the high contracting parties. It further on stated that the responsibility of contracting party may also arise. In that specific case, it was a consequence of the military action, but in general, court mentioned whether it's a lawful or unlawful action. It might arise in the territories where contracting parties is exercising a effective control outside of its national territory. So this is the last example I wanted to mention in my presentation. Alexander, happy to pick up any questions. I will check. It seems like we have some. No, not. I can't see it in my chat.
Yeah, Olga, thank you very much for your presentation. We do have a question relating to the disputed territories. It is actually related to jurisdiction when it comes to disputed territories. So if you could very briefly run through it, I will read it. What are the specifics of territorial jurisdiction of an arbitral tribunal in territories with joint administration? I guess this is the most crucial part of the question here. What are the aspects of territory to be considered, and what is the test for jurisdiction?
So I would, well, again, it was also one of the, I think mentioned by Catherine's, right, that a lot of cases we are dealing with are very fact specific. So since the question, as far as I understand, is specifically coming in the context of the moot problem, I would really highly advise reviewing the specific treaties at hand, also going through some of the criteria mentioned in my presentation, like the scope, the purpose of the treaties. There are some, for example, there is some case law, just mentioned case law of the European Court of Human Rights at the end. There are some cases relating to Transnistria, where both, for example, the Russian Federation and Moldova were acting as respondent states, because the European Court of Human Rights found that, well, in that case, in disputed territories, on the one hand, some obligations of states might arise because of the de facto exercise of either control or at least support of the local self-imposed administrative authorities. On the other hand, the European Court of Human Rights also highlighted that some specific obligations still existed on the part of Moldova, because Moldova as a state also had to follow and try to live up to its obligations with regards to, in those cases, certain individuals and their rights as a sovereign in that territory. So I hope, I mean, it's not a straightforward answer to the question, but I hope it provides some guidance to the person that asked the question.
Yeah, Olga, thank you very much. And then we will be moving on. You need to wrap the presentation to screen sharing. Yeah, thank you. And we will move on, and I will pass the microphone to Peter Tsang, the Associated Polyhogue. Peter, with the topic of multi-party arbitration, the floor is yours.
Hello, everyone. Let me pull up my PowerPoint presentation as well. So I would like to echo the thanks to the organizers for inviting me, and also to the audience for attending this session. My name is Peter Zen. I am a lawyer at the law firm of Foley Hoag, where we exclusively represent states in their public international law disputes, as well as in investor-state arbitration. I have to say, though, that today I am not representing any particular state or any law firm. I'm speaking in my own personal capacity, so I would appreciate it if anything I say is not attributed to any entity that I might be affiliated with. With that said, my topic today is multi-party arbitration, which is really a huge subject. But after looking at the case study briefly, I think there are two issues that I would like to focus on today, and in rather broad strokes, because of course time is very limited. The first is the appointment of arbitrators in multi-party arbitration, and the second is consent to multi-party arbitration. And to get right to it, starting with the first topic, the appointment of arbitrators, I would like to direct everyone's attention to the photograph on the PowerPoint slide there. It's tinted blue, but I can make it clearer here. Excuse me. Many of you may know that this is, of course, Wimbledon, the location of the annual tennis championships. But what many of you might not know is that Wimbledon also happens to be the name of the very first contentious dispute that was brought before the World Court, at that time called the Permanent Court of International Justice, or the PCIJ. Now, this case raises actually some very interesting issues of multi-party disputes. But in order to explain this, this element of the case, I will need to give a little bit of background. So as many of you know, or excuse me, I should say that the case was not about tennis, in case anyone was curious. It was about the steamship called the SS Wimbledon that you see here now on your screen. So turning to some background, this is, if you can see on your screen, the Peace Palace in The Hague in the Netherlands, which is currently home to the International Court of Justice, but used to be the home to the Permanent Court of International Justice. And you can see that permanent court now on your screen in this black and white photograph. It had a very interesting composition, which differs from the International Court of Justice today or to any arbitral tribunal. It actually had 11 judges on the court. But when the framers were designing this court, they wanted to make sure that there wasn't any kind of appearance of impropriety or lack of fairness. So they decided that if there was ever a dispute between two states before this court, then each state could check to see if it had a judge of its nationality already on the court. If it did not, then it had the right to appoint what they called a national judge. These days we call it a judge ad hoc. But if the state did not have a judge of its nationality on the court, then it could appoint an additional judge to hear the case with the other 11 members. So what this means is that you could have, in theory, if both states did not have a judge of its nationality on the court, you could have 13 judges listening to a case. Now, let's turn back to the SS Wimbledon case, the very first contentious case that came before the PCIJ. What was interesting here is that there were actually 4 applicants. It was not a simple bilateral dispute. The United Kingdom, Japan, Italy, France on the one side versus Germany. And if you look closely at the composition of the bench of 11 judges of the PCIJ at the time, and I should say this is not a note that is commonly commented on in the literature, but if you look into the details, you'll see that one of the judges, Lord Finlay, was actually a British national. A second judge, Judge Oda, was a Japanese national. Then we had Judge Anzalotti, an Italian national, and Judge Weiss, a French national. By contrast, Germany did not have any judge of its nationality on the bench, so it had the right to appoint one national judge, and it chose Judge Schucking, who later became a permanent member of the court. But what you see here is that in this very first contentious case, where they tried to develop this equalized system of states appointing judges to the court, similar to what you have in arbitration, there wasn't really much equality. You had 4 judges of the nationality of an applicant, and only 1 judge of the nationality of a respondent. And perhaps it shouldn't surprise you that the applicants prevailed in this case. I think many of you can already see the similarities here with what could happen in an arbitration proceeding in the appointment process in a multi-party context. But let's say that this were an arbitration. Let's say that this were a modern arbitration between these 4 states and Germany. I mean, would we really think it's fair if each of the applicant states could appoint 1 arbitrator and the respondent could only appoint 1, and perhaps there would be 1 additional arbitrator who would be the presiding arbitrator? I think a lot of us would find this perhaps not very balanced. What you see perhaps more commonly these days is that the applicants or the one side of the dispute that has more than 1 party will then agree on a single arbitrator to be appointed for their side, and the other side can appoint 1 arbitrator, have this sort of situation with a 3 arbitrator tribunal. Or maybe another option is to say neither of the sides can appoint any arbitrator. And actually the 3 arbitrators, or 5, or however they may be, shall be appointed by some other external authority. Now, what is interesting is that if you look at history in the context of interstate arbitrations, actually multi-party arbitrations were quite common. So one of the earliest cases of the Permanent Court of Arbitration, this was the blockading powers case, Germany, Great Britain, and Italy versus Venezuela. they adopted the format such that neither of the parties could appoint any of the arbitrators. And it was Russia that actually made this appointment of the 3 individuals on the tribunal. Another example, the famous Japanese house tax, Germany, France, and Great Britain on the one side and Japan on the other. Here, they adopted the situation where you have a 3-member tribunal and each side could appoint 1 member, such that the UK or Great Britain, Germany, and France all agreed on a single arbitrator to appoint. And if we turn to investor-state arbitration, which I understand, of course, is the topic of the case study, this is actually quite common. So this is one of the biggest multi-party arbitrations we've seen, Abaclat v. Argentina, where there were over 180,000 claimants in the case, at least in the beginning of the case. And in that situation, it was generally agreed, there was no significant discussion on this point, that all the claimants would together appoint a single arbitrator and the respondent would appoint a single arbitrator as well. So it seems like a consensus has developed in a way in investor-state arbitration where, yes, when you have multiple claimants, which is quite common in investor-state arbitration, they have to agree on a single arbitrator to appoint. And this makes sense because I don't think we want to see what we saw in the SS Wimbledon case again. But I think where the case study before all the participants in this moot court competition starts to strike new ground is that you don't see in investor-state arbitration very frequently, if at all, multiple respondent states. And so then the question arises, do you adopt this methodology that has already been accepted for claimant's side and say that respondents together in a given arbitration have to only appoint 1 arbitrator? Or do you look to a situation like the SS Wimbledon case where it was accepted, at least in that case, that each one of the states in question could have a national judge on the court? I will not be answering that question today, but I leave that to the rest of you to ponder. I will now briefly touch on the second topic of my presentation, which is consent to multi-party arbitration. And the issue here, of course, arises because with most arbitration agreements today, whether it's a contract or a treaty, they often do not expressly provide for consent to multi-party arbitration. More frequently, they will provide for consent to arbitration, and the question arises, can you actually have a multi-party arbitration? And what I would posit is this. The question of whether you can have a multi-party arbitration depends on whether you can have a consolidation of separate arbitrations. What does that mean? Well, if we take a look at the SS Wimbledon case, let's assume for a second that it were an arbitration. The question of whether you can have this multi-party arbitration would depend on whether, if it were the case that all 4 states had instituted individual proceedings against Germany, whether those 4 cases could then be consolidated into a single proceeding. If they can be consolidated, then of course, multi-party arbitration is possible. So then the next question is, when can a case be consolidated? And here there's a lot of literature, a lot of authority. I will point to just one of them for this presentation, and that is the most recently updated version of the arbitration rules of the International Chamber of Commerce, where it says the court may consolidate 2 or more arbitrations under one of 3 conditions. 1, the parties have agreed to consolidation, but we already said before that we're not talking about a case of express consent. We're trying to see whether it's possible if multi-party arbitration is not mentioned in an arbitration agreement. 2, all of the claims in the arbitrations are made under the arbitration agreement or agreements. Or 3, the arbitrations are between the same parties and some other specifics. This third option is also not really relevant for us because here we're talking about a situation where you're transforming a bilateral arbitration into a multi-party arbitration. Third situation here is assuming that the parties are going to stay the same, so originally multi-party or not. And so what we're really looking at is the second condition, whether all the claims in the arbitrations are made under the same arbitration agreement or agreements. And you can imagine a few scenarios here where a consolidation or a multi-party arbitration might make sense. So as in the SS Wimbledon case, if all the states involved were parties to the same treaty that had the arbitration agreement, in that case it was a compromissory clause, then it would seem permissible to then consolidate the proceedings. But here's the question that I think is more interesting. What if, hypothetically, we actually had 4 different treaties, each one with Germany, but what if they were identical in text? Now, this might seem kind of ridiculous. Why would you have 4 separate identical treaties? But of course, today in the world of investment arbitration, we have bilateral investment treaties that are very, very similar, in some cases perhaps identical, aside from the names of the parties. And the question arises, if you have these nearly identical treaties, can these cases then be consolidated, even though technically it's not the same arbitration agreement? And I would also say in contractual disputes, this is actually not an uncommon scenario. You can imagine situations where a country issues a model concession contract for investors to invest in its natural resources. And all the investors that sign up to pursue one of these concessions have to sign this same model contract. So you have the same exact contract between the parties, at least the text is the same, but technically they're different documents. And yet if we were to apply the ICC rule strictly, at least the second condition right here, all of the claims in the arbitrations are made under the same arbitration agreement or agreements, that technically would not suffice. So again, I'm not providing any answers here. I'm just providing some questions, some food for thought. And that is all I wanted to say for today on this topic of multi-party arbitration. But of course, I'm open to any questions that may arise from the audience. Although I'm mindful of the fact that I think we are relatively limited on time. So if the organizers think it's necessary, we could pass on directly to Simon's presentation. Thank you.
Yeah, Peter, thank you for your presentation, and thank you very much for sticking so precisely with the timing. We do have a question with regard to appointment of arbitrators, and I think we do have like kind of a minute or two to very quickly run through it. So the question is, how does the appointment of an arbitrator in a multi-party arbitration correlate with the principle of the equality of the parties?
Sure. So I'll try to address this very briefly, again, mindful of the time. I mean, I think, of course, the principle is generally respected when you have a typical arbitration between 2 individual parties. Each party gets to appoint 1 arbitrator in most circumstances. So when you have multiple parties on one side, I think the question will boil down to whether those parties are acting in the same interest. If they are acting in the same interest, then really the dispute is between 2 sides, two perspectives, and it's fair, I think, to have those multiple states appoint 1 arbitrator on their behalf. If, however, they have separate interests, then I think the issue becomes more complicated, and one would have to consider whether each interest, each representative side of the dispute has the right to appoint its own arbitrator.
Yeah, thank you very much. I think this is it for this topic for now. So Peter, thanks again. And I will be passing the microphone to Simon Olsen to cover the last topic we have for this panel, joint responsibility of states. For some reason, I don't see Simon, but I think he's here. Yeah, Simon, yeah, the floor is yours. Simon, you would need to unmute yourself.
Thank you, Alexandra. I would like to echo, first of all, the other participants in thanking the organizers of this conference for the opportunity to speak. It's a real pleasure. Today, I'm going to be looking at the question of responsibility of multiple states. And in that regard, as a first point, this is a point which will, to some extent, dovetail with what Peter has said. I wanted to just have a look at the fact that there have been relatively few cases between international courts and tribunals in which multiple states have actually been sued as co-respondents. Now, before the International Court of Justice, the most common situation is in fact that even when multiple states are said to be responsible for a particular wrongful act, the cases are started by separate applications. So to give a few examples, there's the Nato cases started in 1999, which were brought by the SFRY in relation to the joint conduct of the NATO states, and those cases were started as 10 separate claims. The situation was complicated by the need to rely on a variety of jurisdictional bases, and particularly insofar as only some states had made declarations under the optional clause. Similarly, in the Marshall Islands cases, individual claims were made against 9 states, which had or were suspected of having nuclear weapons in respect of their respective alleged breaches of international law, including under the Non-Proliferation Treaty, in relation to cessation of the nuclear arms race and nuclear disarmament. And separate applications were filed against China, North Korea, France, India, Israel, Pakistan, the Russian Federation, the UK, and the United States of America. But only 3 of the respondent states, the UK, India, and Pakistan, had made optional clause declarations, and only those cases were entered in the general list as separate cases and subsequently were heard by the court. Now, even where claims are brought under a single instrument or a compromise, the cases may still be brought as separate claims. And a good example in this case is the Lockerbie cases. These were separate claims brought against the US and the United Kingdom under the jurisdictional clause contained in the Montreal Convention in relation to their conduct, the same conduct allegedly in breach of obligations. But those were brought as separate cases. And on the other hand, though, it does occasionally happen that a case is brought against multiple states before the International Court and results in a single case. And a good example, or perhaps the only example in this regard, is the Monetary Gold case, which was brought by Italy against 3 members of the Tripartite Commission, the UK, US, and France. But Monetary Gold is an exceptional case, and there was a specific jurisdictional agreement in that regard. And in any case, it's not in fact a case about responsibility of the respondent states. Now, looking further afield, before the European Court of Human Rights, there are somewhat more cases with multiple respondent states. And on the slide, there are some examples. You can see Drozdsen, Janicek, and France and Spain, which related to the alleged joint responsibility of the 2 states in respect of Andorra, on the basis of the rather unusual constitutional arrangements which exist in relation to Andorra. But the conduct was held by the European Court to be that of Andorra, and on that basis it held that it had no jurisdiction. Similarly, Bankovic, another case arriving out of the NATO bombing campaign in the late 1990s, again, this was in respect of joint conduct, so it was a case of real shared responsibility. But that failed on the grounds that the ECHR was held not to be applicable to conduct, the conduct in question. I'll skip over the next 2 cases. MSS and Belgium and Greece is a case in respect of ill treatment of refugees or asylum seekers and breach of the prohibition of refoulement. Now here, although the claims were interrelated, they were brought against the 2 respondent states, each in respect of their own conduct and in respect of discrete breaches. So it isn't a case of joint responsibility. It's a case of 2 claims of responsibility against states being brought in a single set of proceedings. And then finally, there are the various cases involving situations of occupation or secessionist movements, which have been referred to, some of them have been referred to by Olga, where both the occupying or intervening state exercising control and the territorial state are sued as the respondents. But again, in this case as well, conduct is in respect of different conduct and in respect of different injury suffered by the applicants. So true cases involving the responsibility of multiple respondent states are comparatively rare. One notable exception in this regard is the claims brought by Qatar before the Council of the International Civil Aviation Organization under the Chicago Convention and the International Air Services Transit Agreement, IASTA, which were then the subject of appeals in the recent ICAO cases before the ICJ. Now, the claims before the ICAO Council were brought by 2 applications under the 2 instruments, which contained separate jurisdictional provisions. So there was one case against all 4 states under the Chicago Convention, and in the other case, there was a claim brought against the 3 states parties who were party to the IASTA. The fact that those cases proceeded as cases against all 4 states together is probably explainable by the fact that under the relevant jurisdictional clauses, the jurisdiction was conferred on the ICAO Council, so that there was no need to constitute a tribunal, and the cases would therefore have been heard by the same body in any event. And that can be contrasted with the situation in the arbitrations between the same parties under the regulations of the UPU, in which, as has been reported in various places, the claims have proceeded as separate cases and separate tribunals have been appointed. Now, the reason for the general rule of separate proceedings is fundamentally related to considerations relating to the basis of jurisdiction and consent. But at the same time, it also reflects a fundamental underlying principle of the law of state responsibility, namely the principle of independent or separate responsibility. And that's the notion that in principle, each state is responsible for its own actions and omissions. The introductory commentary to Part 1, Chapter 4 of the Articles states, and I quote, "Each state is responsible for its own internationally wrongful conduct, i.e. for conduct attributable to it, which is in breach of an international obligation of that state." And this principle is evident in a number of areas of the law of state responsibility. For instance, in the rules relating of lending of state organs in Article 6 of the Articles, and that's the situation which was at issue in Drodz and Janicek, and in the rules relating to aid and assistance in the commission of an internationally wrongful act contained in Article 16. In terms of case law, it's perhaps most clearly illustrated in the decision in certain phosphate lands in Nauru. Now, the question in that case was whether Australia, as one of the three states forming part of the administrating authority for Nauru under a trusteeship agreement and previously under a League of Nations mandate, could be sued alone in the absence of the UK and New Zealand, who were the other two states. And this in respect of an alleged obligation to restore the lands which had been mined for phosphates prior to independence. Now, the case is perhaps better known for the court's pronouncement in respect of the other limb of this argument, which raised the monetary gold principle and the question of whether Australia could be sued without the UK and New Zealand also being party to the proceedings. The first limb of the argument, however, raised the question of whether any liability of Australia was joint and several, or in French, solidaire, with that of the other states, such that any claim could only be brought against them jointly. Now, the court held in that regard that the question of the character of any responsibility of Australia, and in particular whether it was joint and several, was one for the merits. It also held, however, that whatever the character of that responsibility, it did not affect either the court's jurisdiction or the admissibility of Nauru's claims. And you can see the quote on the slide. The court held that it did not consider that any reason has been shown why a claim brought against only one of the three states should be declared inadmissible in limine litis, merely because that claim raises questions of the administration of the territory which was shared with two other states. And as the court carried on, it can't be denied that Australia had obligations under the trusteeship, the trusteeship agreement in its capacity as one of the three states forming the administering authority. And there's nothing in the character of that agreement which bars the court from considering a claim of a breach of those obligations by Australia. Now, it might be argued that this holding is limited to the particular facts of the case, since Australia, in fact, had preponderant responsibility for the administration of Nauru, both under the trusteeship agreement and as a matter of fact. Further, the court carefully expressed its findings, as you can see, by reference to the particular situation before it, including the terms of the trusteeship agreement. Nevertheless, the court's approach in this regard has been taken as reflecting the wider and more fundamental principle of independent responsibility, and this notably in the ILC's commentary on the Articles. The ILC's commentaries on the Articles likewise refer to the decision in Corfu Channel, and they note that despite the fact that it was relatively clear that other states had been involved in and were in fact responsible for the laying of the mines at issue in that case, this was not held to preclude the responsibility of Albania for breach of its duty to warn international shipping of the presence of the mines in the channel. So no impact on the responsibility of Albania as a result of the fact that other states might likewise have incurred responsibility. And the facts of these two cases, Nauru and Corfu Channel, illustrate clearly an evident distinction in respect of questions of joint responsibility, namely that between first, situations in which multiple states incur responsibility for the same internationally wrongful act, and that's normally as a result of some form of joint action, And second, situations in which multiple states are responsible for diverse internationally wrongful acts, all of which, however, have contributed to or resulted in a single injury. Now, in this regard, whilst Article 47 of the ILC Articles is entitled Plurality of Responsible States, it only in fact expressly deals with the former situation, that is, that in which multiple states are responsible for the same internationally wrongful act. And Article 47 is actually of comparatively limited scope. Paragraph 1 is little more than a restatement of the principle that when there are multiple responsible states, the responsibility of each can be invoked separately, i.e., this is a manifestation of the principle of independent responsibility. And paragraph 2 is also of limited scope. Paragraph A sets out the obvious principle that a state cannot recover more than the damage it has actually suffered, no matter the number of responsible states, whilst paragraph B is a pure saving clause, which leaves open the question of contribution as between those responsible states. The commentary is clear that Article 47, and I quote, neither recognizes a general rule of joint and several responsibility, nor does it exclude the possibility that two or more states will be responsible for the same internationally wrongful act. Whether this is so will depend on the circumstances and on the international obligations of each of the states concerned. But as the articles also elsewhere make clear, the general position under the international law of responsibility in respect of the obligation to make full reparation, as enunciated by the Pcij in Factory at Horzoff, and as reflected in Article 31 of the articles, is one of responsibility for all injury caused by an internationally wrongful act. And in this regard, as the decision in Corfu Channel demonstrates, there is no attenuation of the obligation to make full reparation and to wipe out the consequences of an internationally wrongful act, due to the fact that there may have been concurrent causes resulting in a particular injury, or other states may potentially also be responsible. As such, each state which has contributed is in principle responsible in full for the entire injury, which in fact flows from its breach of its international obligations. The situation as between multiple responsible states, and in particular the extent to which a state which has made reparation may then claim against a co-responsible state, is significantly underdeveloped, although it may be noted that in following the decision in Nauru, Australia settled the claim, although not accepting liability, and in doing so, it received contributions from the UK and New Zealand. Article 47 undoubtedly to a significant degree constitutes progressive development of the law of state responsibility insofar as it is built upon relatively sparse state practice. And that's particularly the case as regards the saving provisions in paragraph 2, which are justified as much on the basis of logic and inductive reasoning as they are on examples of concrete practice. But precisely for this reason, it's arguable that the same principles are applicable also in respect of the second type of situation, i.e. where the same injury results from different internationally wrongful acts. Notably, this is the position taken in the guiding principles on shared responsibility in international law, which are the output of a major research project at the University of Amsterdam and were published last year in the European Journal of International Law. Now, the guiding principles deliberately mimic the format of the ILC's work output, and they identify, as you can see, the key distinguishing feature of what is referred to as shared responsibility as being the causing of indivisible injury, resulting from or contributed to by one or more internationally wrongful acts committed by multiple international persons. And it is suggested that the same general approach applies in both situations. The question then is one of application of the normal principles of causation to determine for what injury a state is in fact responsible. I am, I think, running out of time, and I won't attempt also to deal with the separate question of causation, which is a topic for a separate talk entirely on its own. I will just note in this regard that the principles distinguish as regard causation between situations of individual contribution to injury, which will normally be the situation in respect of a single internationally wrongful act for which multiple states are responsible. And then, as you can see in paragraph 2, of either concurrent contribution and cumulative contribution. The latter two possibilities clearly apply to the situation of multiple internationally wrongful acts by different states, which nevertheless contribute to the same injury. Now, finally, as to contribution and recourse, I would simply note that the guiding principles take a clear position that a responsible state which has paid compensation is always entitled to seek contribution or to have recourse against other responsible states who are also responsible for the same injury. I'll terminate my presentation there. Thank you very much for your attention.
Thank you very much, Simon. I've got a question which I already addressed to Catherine in the very beginning, and I think it will probably be good if you elaborate on it a bit as well. So is there any difference in these guiding principles you just quoted with regard to the attitude to the application of the rules on the state responsibility, those which we have in the draft articles of state responsibility? So is there any difference in the approach, and generally what would you think are the draft articles on the responsibility of states applicable in the investor-state arbitration?
Okay, first of all, the guiding principles are really addressed to questions of interstate responsibility. Partly, I think, because of the dearth of questions of investment treaty cases with multiple respondent states. They do also deal with, or they touch upon, the practice before the European Court. So they relate to state responsibility for violations of human rights where individuals have brought claims. But they really are aimed, I think, at questions of interstate claims. Now, as to the applicability of the articles on state responsibility to situations of state responsibility, I very much agree with what Catherine said. And the only point I would add is that I think a distinction has to be drawn between the different parts of the articles. And that's as a result of the way in which the articles are phrased. Part one of the articles is phrased solely with a focus on the obligations of the internationally responsible state, and purports to lay down general rules which apply to any question of state responsibility, no matter to what entity that responsibility is owed. And there's therefore no reason why the provisions of part one, so the questions on breach and attribution and so on, cannot be applicable in investment treaty arbitration. And you see that in multiple investment treaty decisions where, for instance, the rules of attribution are said to reflect customary international law and are applied as such. The situation in relation to the provisions of part two is different, because part two and part three is different. One, because there's an express provision in, I think, Article 30 of the articles, which says that the consequences set out in this part are expressly limited to responsibility owed to another state and are without prejudice to the question of responsibility in respect of other entities and or individuals under international law. And as regards part three, obviously the question of invocation is fundamentally concerned with questions of invocation in interstate cases. It's the way they're drafted. They really focus on invocation by another state rather than questions of responsibility in investment treaty arbitration.
Okay, thank you very much. We do have some other questions, but I'm afraid we only have time for one. And I would address it to Catherine. We've got a question with kind of cherry picking succession, whether the succeeding state can decide what to, can select which obligations to kind of recognize and which not to recognize and not to assume. What would you think? Is it at all possible?
Thank you very much, Alexandra, and thank you for the question. I think ultimately what matters is whether a state, whether a state has a responsibility, and if it doesn't, it may not be able to avoid it. So it will depend in what kind of situation we find ourselves. For one thing, under Article 11 of the ILC Articles on State Responsibility, a state may conduct which is not attributable to a state will be considered as an act of the state if and to the extent that the state acknowledges and adopts the conduct in question as its own. So if a state does not really have responsibility, ultimately if it does, we may arrive at the conclusion that the state will bear responsibility if it considers that, if it recognizes responsibility. And I would just like to point out that we have cases where I gave an example where, for instance, if we have a devolution of powers to local authorities, then we have an exception to the non-succession rule. So it may be that for some acts a state has responsibility and for some others it doesn't. So it may in fact be selecting in the sense that it is identifying for which acts it really has responsibility and for which ones it doesn't. And by way of a final comment, this is something that we also saw in the Lighthouse's arbitration, where for some of the claims, the arbitral tribunal found that a state had responsibility, the successor state, and for some other cases that it didn't. So it doesn't mean that if a state has responsibility, it has a responsibility. The successor state or the predecessor state, it doesn't mean that it has responsibility for everything. Thank you.
Catherine, thank you very much. And I guess we need to close the session now. I thank you all the speakers. Once again, Peter, Olga, Catherine, Simon, thanks a lot. And very big thank you for the organizers again. And thanks to the audience for the questions. I hope there was a good session. Yeah, so with this, I think we are closing.
Thank you.
Good evening. Welcome back to the Moscow FIAMC Pre-Moot conference. It's a cold but a lovely, white and frosty evening in Moscow, and it's Friday. So thank you very much for taking your time to be here with us at this investment arbitration event. And we are starting the second session of Moscow FIAMC Pre-Moot conference. My name is Elena Burova, and I will be moderating this session. On the agenda of our session, we have the following topic: define investor and its nationality for the purposes of investment treaty arbitration. And this topic is pertinent not only for this year problem of FIAMC moot competition, but it's actually relevant for every lawyer who is practicing investment arbitration, because one way or another, all of investment arbitration practitioners had to grapple with this broader topic in his or her experience. And during the next hour and a half, we will listen to the presentations of the prominent arbitration practitioners on this one of the most important and I would say fundamental topics of investment arbitration. And now I have the honor to introduce our speakers to our audience, and I will do this in the order of our presentations. Our first speaker is Professor Christoph Schoyer. And Professor Schoyer is a person who truly does not need any introduction to those people who are involved with investment arbitration, even to a certain extent. And Professor Schoyer's career spans over more than 40 years. And his main product of work, the main product of his activity is 1,500-page commentary on the ICSID Convention, which is entitled The ICSID Convention, a Commentary. And another famous product of his work is the so-called Green Book. At least this is how we refer to it during my studies in Uppsala University. And this is the Bible, if I may, of investment law, the book which was co-authored with the late Professor Rudolf Dolzer, The Principles of International Investment Law. Now Professor Schoyer is of counsel at Zahler Floyd Zetkovich. And Professor Schoyer is based in Austria, Vienna. He acts occasionally as an expert on the matters of investment law and public international law in arbitral proceedings, and he also serves as an arbitrator in ICSID and the Untitled Cases. It is my great honor to meet you also online, Professor Schoyer, and Professor will address the topic of intertemporal elements of consent in investment arbitration. Moving to our next speaker, I am glad to introduce to you Joe Tirado. Joe is a partner and co-head of international arbitration and ADR practice in the law firm Garrigues, and Joe is based in London. Joe has close to 30 years of experience in dispute resolution, representing sovereign states, multinational corporations, and high net worth individuals. Joe has hundreds of cases across his experience as a counsel, arbitrator, and mediator, as well as an emergency arbitrator in investment treaty case. And also, Joe has conducted and advised on international commercial and investment arbitrations around all major international arbitration rules and before almost all leading international arbitral institutions. But another important fact from Joe's experience, when I browsed through his CV at the website of his firm, is that Joe quite frequently acts as an arbitrator or judge in student arbitration or dispute resolution competitions. And as I have recently known from Joe, he will be arbitrating the finals of Moscow FIAMC Pre-Moot this year. Welcome, Joe. Finally, our third and last speaker today is Bart Legum, and I'm equally happy to introduce Bart to our audience. Bart is a partner in the Paris office of Dentons And Bart is also the head of the firm's investment treaty arbitration practice. Bart has over 30 years of experience in litigating complex cases, and he has argued before numerous international arbitration tribunals, the ICJ, and a range of courts in the United States. Earlier in his career, Bart served as chief of the NAFTA arbitration division in the Office of the Legal Advisor of the US Department of State. And in that capacity, Bart acted as a lead counsel for the United States in a number of first investment treaty arbitrations under NAFTA. And the US won every case decided under Bart's tenure. So welcome, Bart. Pleasure to have you tonight in our panel. Let me briefly describe the mode in which we will proceed within our panel. We will first proceed with the presentations by each speaker, and each speaker will have up to 10-15 minutes. And after that, I will give the floor to the rest of our panelists who can provide their comments or questions. And also, depending on the questions from the audience, we will also address them after each presentation by the speaker. I would also like to take this opportunity to encourage our audience to be proactive and not hesitate to ask your questions, because this is a great, I would even say, unique chance to do that tonight. So you can make use of it in the Q&A box below, either in YouTube or in any other browser where you follow our broadcasting. Without further ado, I will pass the floor to Professor Schoyer, and the topic of his presentation is intertemporal elements of consent in investment arbitration.
Thank you very much, Elena. Since you were kind enough to mention two of my books, this gives me the opportunity to mention that there will very soon be third editions of both of them. In fact, this year, later this year. Okay, I want to briefly touch on three topics. The first one is, what is the time of consent? The second is, why is the time of consent relevant? And the third one is temporal restraints on consent. I'll explain that later on. When you look at the time of consent, you have to remember that consent is always by agreement. The agreement must be perfected. An offer of consent is not enough. In fact, the institutional rules of the ICSID Convention give the definition of the time of consent. They say the time of consent means the date on which the parties to the dispute consented in writing to submit it to the center. And if both parties did not act on the same day, it means the date on which the second party acted. So what does that mean if both parties did not act on the same day? Well, you could have a consent document that is signed on different days. That's not particularly spectacular. Or you could have a document that offers consent that is later accepted by the other party. For instance, an investment application that is later accepted by, approved by the state. But of course, the most important and spectacular situation is where the state gives a general offer of consent, either through legislation or through a treaty. In that sort of situation, the time of consent is where that offer, that general offer, is accepted by a particular investor. At the latest, the acceptance must take place when proceedings are instituted. But that is not the only situation. An investor may accept the offer of consent earlier on, even before a dispute arises. You often read, well, not often, but sometimes read that in treaty arbitration, the day of consent is always the initiation of proceedings. Now, that is not entirely correct. It usually is, it often is, but it ain't necessarily so, to use a famous quote. It can be earlier. There are no time constraints on an investor, but it is advisable for an investor to accept as early as possible. Sometimes the acceptance of consent is subject to certain conditions. For instance, if you arbitrate under the ICSID convention, both the home state and the host state must be parties to the ICSID convention. In some situations, it is possible that consent is given before these states have acceded to the ICSID convention. In that situation, the date of consent will be the day when both states parties have become party to the ICSID convention. In fact, that was the case in Holiday Inns, the very first ICSID case. At the time that consent was given, neither of the two states, home state, host state, were parties to the ICSID convention. But later on, they did join the ICSID convention. And when the case was initiated, the consent existed and was perfected because both parties had joined the ICSID convention. Now, let me move on to my second topic. What is the relevance of the time of consent? Consent, once perfected, has several consequences. I'll first list a few that are not so interesting, and then I'll zoom in on one that I think is really interesting. Well, under the ICSID convention, nationality is determined as of the date of consent. So that's a relevance of the date of consent. Or exclusion of other remedies under the ICSID convention takes place as from the date of consent. Prohibition of diplomatic protection is as from the date of consent. And a topic that will be quite interesting in years to come is the latest version of the ICSID arbitration rules. The relevant arbitration rules will be determined as of the date of consent. As you probably know, the ICSID arbitration rules are undergoing revision and there will soon be major changes. So if you still want to arbitrate under the old rules, you better consent now and don't wait. Okay. Now, the most important consequence of consent, of perfected consent, is the irrevocability of consent. So once consent is given, you can't revoke it unilaterally. Obviously, you can do it by agreement, but that would be very unusual. That, of course, is a manifestation of the principle pacta sunt servanda. If you have an arbitration agreement in a document, that document is binding, including the arbitration agreement, and you can't take it back. But this also applies where the consent has been perfected on the basis of legislation or of a treaty. But of course, it only works once the consent has been perfected through acceptance. Therefore, it is not advisable for an investor to lean back and say, I have this permanent offer of consent to arbitration under legislation or under a treaty, therefore I don't do anything and I just wait for things to happen. And if they do happen, I can always accept and start an arbitration. It is highly advisable to accept the offer of consent as early as possible, otherwise it might slip away. Now, one context in which irrevocability plays a role, where you have a specific provision even in the ICSID convention, is the denunciation of the ICSID convention. Theoretically, a state could can always revoke or denounce the ICSID convention and then say, well, I'm no longer a party to the ICSID convention, therefore there is no jurisdiction. Now, Article 72 blocks that avenue for perfected consent by providing that a denunciation shall not affect the rights and obligations arising out of consent given before receipt of the notice of denunciation. There are various ideas about exactly how Article 72 operates, but this is not the time and place to talk about the details of a denunciation. Another important instance of irrevocability is the repeal of national legislation. Obviously, a state can at any time change its legislation, and it can also repeal an offer of consent that has not been taken up. However, once it has been taken up, it assumes an independent existence, a contractual existence that is independent of the validity of the legislation as such. In other words, it gets insulated from the legislative nature of the offer. Once you have accepted it, withdrawal of the legislation will not affect consent. The most spectacular question, of course, here is the termination of a treaty providing for consent. Now, treaties obviously are more difficult to terminate than legislation for a state. Treaties can only be terminated under the law of treaties, but something that for a long time seemed a remote and theoretical possibility has now become a reality, namely the termination of treaties providing for consent. For instance, last year, most EU member states entered into a multilateral agreement that purports to terminate all their intra-EU BITs. Now, what does that mean? I'll get back to that in a moment. But if you have accepted the offer of consent in one of these treaties, you're relatively safe, because then it becomes irrevocable and you can't take it back. Many treaties, many BITs have so-called sunset clauses. The sunset clauses say that the treaty, even after its termination, continues to be in force, continue to apply for a certain period of time for investments made before its termination. Now, there is limited comfort in these sunset clauses. They look very good, but unfortunately, states have come up with the technique to terminate these sunset clauses. For instance, the Czech Republic, but also Italy and some other countries have first amended their BITs to remove the sunset clause, and then they terminated the treaties. So that really deprived investors of that protection. There has been one case that I'm aware of where a tribunal has found that the termination of an intra-EU BIT does not affect perfected consent. The case is called Magyar Farming versus Hungary, but I don't have the time to go into this in much detail. Now, what about the termination or invalidity of an investment agreement, a direct agreement between the investor and the host state providing for arbitration? Sometimes states purport to terminate agreements, or perhaps even more often, they claim it is invalid ab initio. Now, if the agreement containing the arbitration clause is invalid, then at first sight, one would assume there is no consent to arbitration. However, there are two answers to such an attempt to terminate an agreement containing consent. The first answer is that you cannot just claim that the consent agreement or the agreement containing consent is the end of the matter because it is an accepted principle that the tribunal itself is the judge of its own jurisdiction and competence. Therefore, the tribunal must decide. Therefore, you cannot stop the activities of the tribunal simply by declaring the agreement terminated or invalid. The second and perhaps even stronger argument is a general principle that is well established, and that is the severability or separability of arbitration agreements. This means that an arbitration clause in an agreement has a separate existence, rather like a cat that has several lives. So it has a separate existence. Even if the main agreement is terminated, the arbitration agreement survives and continues to apply and gives the tribunal a chance to decide whether the termination or the declaration of invalidity of the main agreement is actually valid. This principle of the severability of arbitration clauses is well established in arbitral practice, not only in investment arbitration, incidentally, and you also find it in various arbitration rules, ICC arbitration rules, Uncitral, and so forth. Let me now move to my third and last topic, and that is temporal restraints on consent. Now, BITs frequently provide that they shall apply also to investments made before their entry into force. However, some BITs state that they shall not apply to disputes that have arisen before that date. Therefore, the decisive time for the validity of consent is the time of the dispute. Now, the dispute is an elusive concept. When does a dispute arise? A dispute is not identical with the events leading to the dispute, and the time of a dispute is not the same as the time of the events leading to the dispute. The acts, the incriminated act, will take some time to develop into a dispute, and there will have to be some communication between the parties. So time of dispute and time of event is not the same thing. You may think that this is a rather theoretical issue, but it is not. It has arisen surprisingly often before tribunal. In several cases, the event started or occurred before a BIT's entry into force, and the tribunals then found that the dispute in its technical sense arose only afterwards. You find that finding in Maffezzini, in Jan de Null, in Hellnan. In all these cases, the tribunals found they did have jurisdiction. But unfortunately, there are some exceptions. Some tribunals did not make this distinction and said, well, the events occurred before the entry into force of the treaty, therefore we have no jurisdiction. I think that's an incorrect finding. That happened incidentally in Mikula too. So the next question, of course, is, doesn't that violate the principle of non-retroactivity? Before you get worked up about non-retroactivity, let me assure you, this was considered by the International Law Commission when they drafted the preparatory work for the Vienna Convention on the Law of Treaties, and it's all covered both by the preparatory work and by the Vienna Convention, although I cannot go into all sorts of details. However, an interesting issue here is, what is the applicable substantive law in a situation like that? If jurisdiction extends to events that took place prior to the entry into force of the treaty, it will be the law in force at the time of the relevant events that will have to be applied to the merits. But these are facts that are not subject to the treaty's substantive standards, because the treaty only entered into force afterwards. It is the rules of international law in force at the time when the alleged wrongful act took place that is decisive. That is the principle of contemporaneity. Again, this is well established. And tribunals have, in a number of cases, applied substantive rules of international law that were not contained in the treaty that was the basis of their jurisdiction. This principle is reflected in SGS versus Philippines and in Salini, in Impregilo, in Jan de Null, Ping An, and so forth. Again, there are odd cases that do not respect this, but found otherwise. However, and this is my last point, so don't get nervous, in some cases, the treaties provide that consent to arbitration is limited to the treaty itself. In that case, the date of the treaty's entry into force also necessarily is the date from which acts and events are covered by consent to jurisdiction. For instance, the NAFTA and now the USMCA and also the Energy Charter Treaty all provide that consent is limited to violations of the respective treaty. So in these cases, you cannot go back, you cannot adjudge events that occurred before the treaty's entry into force. I see that I have spoken 18 minutes. I hope I will be forgiven. Thank you very much.
Thank you very much, Professor, for such an informative and enlightening presentation. It was a big pleasure to follow you, and of course you will be forgiven. I would like now to turn to your fellow co-panelists, to Bart and Jo, and to ask whether you, Bart and Jo, have any comments or input to what Professor Schoyer has just talked about, because otherwise I have in mind one question that I wanted to pose to all of you, maybe.
Well, I'll jump in while Jo finds his mute button.
Found it.
So one question that I have for you, Christoph, is this. It's one that arises frequently in ICSID arbitrations, but I don't think that it's dealt with in detail in your commentary. You referred to this.
Then it doesn't exist.
Then it doesn't exist, of course. You referred to the separability of the arbitration agreement. Yep. And one question that comes up frequently in cases that I'm involved in is, what is the law then that governs arbitration agreements under the ICSID Convention? In other words, if the parties to a contract agree that a certain substantive law will apply to the contract, but then they agree to ICSID arbitration, does the separability of the arbitration agreement imply that a different law may apply to the validity of consent to ICSID arbitration? And if so, what law is that?
Well, I'm not sure if I fully understand the question. That's probably because it's not covered by the ICSID commentary. Applicable law under the ICSID Convention, Article 42, only applies to the substance, to the merits. It does not apply to jurisdiction. Okay? Does that lead us anywhere? Jurisdiction under the ICSID Convention is determined by the convention itself and by the document providing for consent. But I still haven't quite understood how this ties into separability, because separability deals with the existence or not of the document containing consent. Here we're talking about an agreement with an arbitration clause where one party, obviously the respondent, argues is invalid or has been terminated.
So let's say hypothetically that that a party argues that, and this is, let's say, a contract case, a party argues that that there has not been an agreement to ICSID arbitration because of a traditional contractual basis for invalidity, such as fraud or misrepresentations or something along those lines. Mm-hmm. What would be the law that would be applicable to those allegations?
The law applicable to those allegations, I think, would not be affected by the separability issue. It would probably be applicable. The law applicable would probably be the proper law of the contract. That may well be domestic law. The decision would have to be made, if you have an ICSID clause in the contract, the decision would have to be made, though, by an ICSID tribunal, which would apply the proper law of the contract to the issue of termination or invalidity of the contract. Does that make sense?
It does.
Good.
I mean, I could follow up, but I'm not going to. Jo, over to you.
Great question. No, Elena, I was going to say, no, I had no comments on Christoph's excellent overview that he provided to us. That was a great follow-up question, Bart. But Elena, why don't you raise your question?
Thank you, Joe. Yes, my question refers to the multilateral agreement between the member states of the European Union, to which your presentation, Professor Schoyer, referred. And in particular, I noticed that this multilateral termination agreement provides separate rules regarding the legal force of sunset clauses, to which you referred in your presentation. And in particular, this termination agreement expressly envisages that all sunset clauses provided in the intra-European Union BITs lose their legal force. And in other words, these sunset clauses are also terminated by means of termination of the relevant intra-European Union BITs. And my question in this regards to you, Professor Schoyer, and maybe to Joe and to Bart, what do you think? Is there any, let's say, chance that potential future investment tribunals, when addressing this issue or when dealing with the objections of investors to this provision, saying that these provisions may not be applicable for some reasons, do you think that such type of arguments of investors in disputes can be justified? And do you see any risk that further investment tribunals may find that such kind of agreement between the states still does not affect the rights to arbitration of investors under such BITs, although the consent under these terminated BITs have not been yet perfected?
Yeah, well, I think you anticipated the first part of my answer. If it has been perfected, I think the whole termination does not affect consent, because the consent that has been perfected has an independent existence. As to non-perfected consent, which really addresses the issue of the sunset clause as such, the whole thing appears very unfair. And you could possibly make an argument based on acquired rights. There is an interesting article, I think, by Professor Riesman, who argues that a promise of consent, even before it has been accepted, creates an acquired right. But I think that is probably a minority view. And I suspect, my guess would be that you don't have very much of a chance to prevail on this particular argument. I would think that most tribunals will probably come to the conclusion that the masters of the treaty are the states. If they agree to amend or terminate it, even under unfair conditions, even contrary to promises contained in the treaty, that's it. And as to the sunset clauses, a tribunal would probably say that the sunset clause was designed for unilateral termination, because under certain circumstances, a bid can be terminated unilaterally, perfectly legally. And in that sort of situation, the sunset clause would kick in. So in terms of a practical litigation situation, if a client asked me, what are my chances? I would say, as lawyers often, to less than 50%, which means very little.
Yeah, understood. Joe, Bart.
No, all I was going to say, I'd have to agree with that. I think it would be a very brave tribunal indeed to go, I think, against the collective will of the sovereign states. Having said that, to answer your question specifically, which effectively Christoph has covered as well, you can never rule it out. It would obviously depend on the facts of the particular case. But I would thought highly unlikely.
I would agree so far as claims before an investment treaty arbitration tribunal is concerned, if the treaty's already been terminated before consent was perfected. I would simply note that there is authority under both national laws of some countries and the European Convention on Human Rights that claims themselves are property, and that if a state extinguishes claims without further provision for them to be asserted or for compensation, then that can be a violation of human rights treaties or constitutional provisions under national law. But I'm neither a human rights lawyer nor a constitutional lawyer, and therefore I won't offer a view myself.
May I respond to this?
Sure.
Yeah. A counter argument that you would probably run into. I don't necessarily disagree with you, Bart, but a possible counter argument was that what was being extinguished here was not the right, but only the avenue to pursue it. And the European Commission would surely enter a brief, and they would say protection under European Community law is so wonderful and so perfect that you don't need all this jazz with investment arbitration anyway.
Yes, well, I mean, at least as I understand the termination agreement, it terminates the treaties in their entirety.
True.
Rather than just the arbitration clause.
Yeah, that's
so if you had a vested claim prior to the termination of the treaty, then the argument might apply, although the question would then arise, A, why didn't you perfect consent if you had a vested claim?
Yeah.
And perhaps the answer to that is that there were issues with mandatory waiting periods under the terms of the bid, or maybe there were some other impediments. But you're also correct, Christoph, that in order to show damages, you would have to show that it was a claim that couldn't be asserted through other means.
Yeah. Incidentally, mandatory waiting periods probably wouldn't preclude the possibility of perfecting consent, because the mandatory waiting period stops you from starting the arbitration, but it doesn't stop you from sending a letter and say, I accept consent, and I will sue you later.
Yeah, that might be also the case. So unless we have any further questions or comments to the first presentation by Professor Schoyer, I would like to pass the floor to Jyoti Rado, who will present his presentation, his overview on the topic of the meaning of investor. Joe, you have the floor.
Thank you very much. Good afternoon. Dobry den from London. Thank you to you, Elena, for the lovely introduction you gave us earlier on. Let me just reassure everybody, the fact that I am arbitrating on Sunday morning will not influence my decision, I'm sure, on the performance, although, of course, everybody, if people do feel inclined to leave positive feedback after this presentation, that's always welcome. Thank you, of course, also to REMAM and to the conference organizers for inviting me to participate in this event and on this truly illustrious panel with Professor Schoyer and my old friend Bart. So my topic is, as Elena said, the meaning of investor in investment treaty arbitration. Of course, by necessity, due to the limitation of time and the desire to stimulate some discussion, I shall only touch on the key points to bear in mind in considering whether an investor is an investor for the purposes of qualifying for investment treaty protection. I shall therefore avoid a detailed analysis or commentary of the cases that I refer to in this short presentation. Instead, allow me, if I may, to shamelessly plug my own Lexis PSL arbitration practice note that I prepared and recently updated with the invaluable assistance of my colleague, Elisa Vicente, in our Madrid office for LexisNexis. They produce a series of practice notes, and essentially, in the interest of full disclosure, that forms the basis of my talk today, and it has all the full citations there for you. I should also just mention that practice note is a little wider than this more limited view of investor. It also covers the meaning of investment in investment arbitration, but this is outside the scope of the presentation today, and I'm sure that will be the subject for discussion another time. So we all know that the major gateway issue for any claim brought under a bilateral investment treaty, BIT, or a multilateral investment treaty, an MIT, or foreign investment law will be whether the investor actually qualifies as an investor and whether that investor's interest in the host state qualifies as an investment. If a potential claimant is not a qualifying investor holding a qualifying investment under the relevant treaty law, then the substantive protections will not apply and there will be no legitimate jurisdictional scope for pursuing an investor-state arbitration. The definition of investor and investment will vary between BITs, but some overall themes, I think, emerge, and certain components of the definitions are common to many BITs. As I've already indicated, this presentation sets out an overview of those themes and typical issues that arise in relation to the definitions of investor. So an investor will typically mean normally one of two things. One, an individual citizen of the investor's home state, or B, a company incorporated in the investor's home state. However, in the modern world of global citizens and multinational corporations, this issue can be quite complex. So looking at what key elements make up an investor. An investor can be a natural person or some form of legal entity, most often a corporation. If an investor is a natural person, typically that individual will need to prove citizenship of the investor's home state in accordance with the home state's law on nationality. The exact requirements will depend on the wording of the treaty. A number of BITs impose an additional requirement that the individual be resident in the home state. Some BITs also provide specific rules governing dual nationals. For example, the Canada-Argentina BIT defines an investor as, and I quote, any natural person possessing the citizenship of or permanently residing in a contracting party in accordance with the laws, and in respect of Canada, any juridical person, including corporations, partnerships, organizations, associations, or enterprises incorporated or duly constituted in accordance with applicable laws of that contracting party, in respect of the Republic of Argentina, any juridical person according to the laws and regulations of the Republic of Argentina or having its seat in the territory of the Republic of Argentina who makes the investment. Therefore, permanent residents that perform investments are also considered investors in accordance with the BIT. So it's a broader scope for investor. More recently, the Hong Kong China Special Administrative Region and United Arab Emirates BIT that was signed on the 16th of June 2019 and entered into force just last year, almost exactly a year ago, the 6th of March 2020, follows a similar rule when defining investor in respect of the Hong Kong Special Administrative Region, where they're, quote, natural persons who are permanent residents of the Hong Kong Special Administrative Region. However, the same concept in respect to the UAE is different, as it's natural persons who are nationals of the UAE. So you don't have the permanent residence definition there. By comparison, other BITs, such as the Spain-Serbia BIT, only consider nationals as investors where, quote, a natural person having the nationality of one contracting party according to the law of that contracting party, close quotes. So if an investor is a legal entity, often the requirement will be that the entity is simply incorporated in the home state in accordance with the home state's laws on incorporation or constitution of legal entities. However, occasionally there may be enhanced requirements. For example, that the entity has some sort of substantial management presence, sometimes referred to as the place of effective management or its seat within the home state. Some BITs define investor then to include entities that are incorporated somewhere other than the home state, but which are owned or controlled by a national of the home state or a corporation incorporated in the home state. For instance, the Iran-Switzerland BIT defines legal entities that are investors as, quote, legal entities, including companies, corporations, business associations, and other organizations which are established under the law of the contracting party and have their seat, together with real economic activities, in the territory of that same contracting party. Finally, a claimant making a claim at ICSID must prove that it is a national of another contracting state under Article 25.2 of the ICSID Convention. So looking at potential complexities, you will see that complexities often arise when the investor is a corporation. Often the corporation, which is formally the claimant, will be part of a multinational corporation or a group of related companies. Issues that can typically arise include where the investor is a holding company with no de facto management powers or responsibilities, or where the investor is an indirect owner of the investment via a holding company in a third jurisdiction. Another complication might be when the investor owned the investment and its knock-on impact on nationality. And finally, another issue might be where the BIT allows for investors to be entities in third states controlled by entities in the investor home state. So looking at these, if I may, in turn very briefly, where we have the holding company as claimant, the investor claimant may be just simply a shell holding company. Of course, the starting point in considering this issue will be the BIT itself, which is, I think, the golden rule for everything that's being said in this presentation, at least. If the BIT imposes a requirement that only the investor is formally incorporated in the home state, a mere holding company will likely meet such a requirement. However, arbitral tribunals have been generally reluctant to hold otherwise based on a plain reading of the relevant BIT. If you look at AMCO Asia against Indonesia or Saluka against Czech Republic, and of course the well-known case of Tokelis against Ukraine, they explore and consider the question of shell companies in more detail. So the BIT may, however, contain a denial of benefits clause that Bart will be examining in a moment. So I don't want to delve into that, but suffice to say that in relation to the question as to whether an investor qualifies as an investor for the purposes of the treaty, such a clause will typically permit the host state to deny the benefits of the BIT to a company incorporated in the home state if the company does not have substantial business activities in the home state. If the BIT contains such a clause, a shell holding company will not be sufficient to qualify. And examples will be the Lebanon, Austria BIT, Japan, Vietnam BIT, and the North America Free Trade Agreement, NAFTA. So turning to the second issue, indirect ownership via a holding company in a third jurisdiction. The claimant may indirectly own an investment via a holding company in a third jurisdiction. Again, subject to the wording of the BIT in question, that claimant typically will still be classified as an investor owning an investment, although complexities can arise from the possibility of more than one arbitration being brought by different entities at different levels of the corporate chain, even where these arise out of the same facts. This was demonstrated in two arbitrations brought against the Czech Republic by Mr. Lauda, one in his personal capacity as the ultimate beneficiary in the corporate chain. That was Lauda against Czech Republic in 2001, and one by a Netherlands holding company under a different BIT. That was CME Czech Republic against BV against the Czech Republic, again of 2001. While one arbitral tribunal rejected the claim, the other found that there had been an expropriation and awarded damages to the claimant. Other cases on this point are the Sedlmayer against Russia, which I'm sure many of our audience would have known and read. Waste Management against the EU against Mexico is another example of case discussing this. Another one is the Standard Chartered Bank against the Republic of Tanzania. This is 2012. Where the claims were submitted on the basis of the UK-Tanzania BIT, and the dispute related to an alleged investment in Tanzania by a subsidiary company of the claimant. That's Standard Chartered Bank Hong Kong Limited, made to the Independent Power Tanzania Limited. The tribunal held that the claimant must have contributed actively to the investment and not the subsidiary. Again, a recent case in the English courts, very recent, of 2019 in the High Court, was the Republic of Korea against Mohammed Reza Dayani. This was a finding that was raised in the context of a challenge under an arbitral award for lack of substantive jurisdiction pursuant to Section 67 of the Arbitration Act. And here the claimants qualified as investors under the terms of the Korea-Iran BIT in respect of investments directly held or owned by a company in which they were shareholders. The court was clear that the language of the BIT was wide enough to give protection to at least a controlling shareholder in relation to the damage to the assets of a company in which the shares are being held. Essentially, the court here can be seen to be adopting a very broad meaning of both investor, and in this case, it's also a good indicative of the court's approach to the meaning of investment. So, whilst each investment treaty arbitration will turn on its own facts, of course, and the interpretation of the relevant treaty, which will be guided by the principles of both international law under the Vienna Convention and of English contract law, the definition of investor, or in this case as well, and for the matter, as a matter of fact, of investment in the Korea Iran BIT is the same or indeed similar to definitions contained in other BITs. So the court's decision may therefore encourage more indirect investors to seek to bring claims and will limit the jurisdictional arguments which may be raised by states in this regard. It is also worth noting that the court's decision to reject Korea's challenge and to generally be persuaded by the reasoning of the tribunal in the underlying arbitration is further evidence of the English court's continuing support of the arbitral process. There may also be issues relating to the timing of the investor's nationality. Generally, a corporate investor must hold the relevant nationality from the date on which the events giving rise to the certain claim occur through to the date of the commencement of arbitration. However, arbitral tribunals have analyzed this issue in different ways, and it has also provoked significant debate in the arbitration community. I refer to the case of Lowen Group against the USA. In another controversial case, the corporate restructuring of holding companies relatively shortly before the arbitration claim was filed did not bar the claimant from qualifying as an investor, even though prior to such corporate restructuring, the claimant would not have qualified as an investor. If we look at the famous case of Aguas del Tunari against the Republic of Bolivia for that, as well as an additional case of Hussein Nuaman Soufraki against the UAE, where the dispute arose from a concession agreement executed by the claimant as a Canadian national. He later commenced proceedings before the ICSID tribunal as an Italian national. A tribunal held that the claimant was not an Italian national under the laws of Italy when the parties consented to an ICSID arbitration and when the claimant's request for arbitration was registered with ICSID. Finally, another incurring issue is whether investors holding both the nationality of the host state and of another contracting party to the applicable investment agreement may resort to investor-state arbitration. Article 25.1 and Article 25.2 of the ICSID Convention expressly precludes dual nationals from bringing an ICSID claim against one of their own states. However, other arbitral fora may prove to be more flexible in this regard. For example, if you look at the panel in the Untitled arbitration of Serafin against Venezuela, they found that under specific terms of the Spain-Venezuela BIT, it had jurisdiction to decide on a claim brought by two dual Spanish-Venezuelan nationals against Venezuela. However, recently in the case of the Bolivian, in another Venezuela case, this time Garcia and Garcia, the Paris Court of Appeal set aside an award as it found that the arbitrators had departed from the cumulative and indivisible requirements of the BIT by failing to consider whether the claimants had Spanish nationality at the time they made their investments. Specifically, the reason for annulment was that the plaintiffs, who have dual Spanish and Venezuelan nationality, did not have Spanish nationality at the time they made their investment. And finally, looking at the question of incorporated, an entity incorporated elsewhere, but controlled by a national of an investor home state, it may be that a BIT might state that an investor can be an entity incorporated somewhere other than the home state, but controlled directly or indirectly by nationals of the home state. Again, if I can refer you to the case of Aguas del Tunari against Bolivia, for background on that. And there's also another case of the Guardian Fiduciary Trust and against Macedonia, where the tribunal declined jurisdiction over the claimant's claims on the basis that the claimant failed to establish that it was a national of the Netherlands for the purposes of the Netherlands-Macedonia BIT. There, the BIT provides a wide definition of national, which extends to legal persons controlled directly or indirectly by a national of a contracting party. I think with that, I'm conscious of time. I've probably just gone over my my allotted time. I mean, suffice to say, what on the face of it seems, that's what so much of it in this fascinating field of investment arbitration seems to be relatively straightforward. There are traps galore, and what may well seem to be relatively straightforward, you clearly, at the risk of stating the obvious, a very detailed analysis and reading of the BIT itself is the prerequisite starting point, but that's not the end of the story. And the reality of it is, if you dig hard enough, you will certainly probably find an example to support whatever position you want to take. And if not, be creative enough to create another exception to what may well be the standard consensus. But the reality of it is, I think there's relatively little that one could honestly say, hand on heart, is written in stone and will be followed in all circumstances. So with that, I'm sorry that it's had to be such a rapid canter. I'm glad I didn't go into more detail about the cases, but thank you for your attention. Happy to take any, obviously very interested to hear comments from both Christoph and Bart and our audience. And with that, spasibo.
Thank you very much, Joe. That was indeed very thought-provoking and stimulating. And indeed, it's not a straightforward task to grapple with these issues of ratione persona in investment arbitration. And I will now turn to Christoph and Joe to seek whether they have any comments or follow-up thoughts that they want to share.
Thank you. You covered so much ground, Joe, that I don't know where to start. But just a few remarks. You spoke about nationality of individuals and corporations. And here there's a very interesting difference to start with, whereas nationality of individuals is mostly determined by the national law of the country whose nationality is in question.
Yes.
The nationality of corporations is usually governed primarily by international law, mostly by the treaties themselves, and they have different solutions. They say incorporation is enough, or some of them will say incorporation plus real economic activity and. So this leads to all sorts of interesting questions. But what you did mention, and I think what is entirely correct, is that overall tribunals seem to think that you cannot add requirements, nationality requirements in the widest sense, that are not in the treaty. Yeah. And of course, Saluka and Tokyo's Tokeles are the typical cases. If it just says incorporation and that's enough, that's it. And even if the corporation is 99% owned by nationals of the respondent state, as in Tokyo's Tokeles, that's just too bad. That is a foreign investor. Now, when it comes to individuals, there are now recent decisions, and you mentioned this, you just went over it relatively quickly, so I'm picking it up again. I'm not saying anything new. Under the Spain-Venezuela bit, there's a very interesting proviso that says if there's a dispute, it shall be ICSID arbitration if ICSID is available. And until Venezuela denounced the ICSID convention, ICSID was available. And as long as ICSID was available, the negative nationality rule applied. That is, if the claimant is also a national of the respondent, he's out. No way. Now, since ICSID is no longer available, the negative nationality rule under the ICSID convention did not apply. And so and there seem to be many dual nationals in Venezuela, Spanish and Venezuelan nationals. And then some clever lawyers must have told them, this is your chance. So in a sense, Venezuela shot itself into the foot by denouncing the ICSID convention, because this opened the field for all sorts of new claimants dual nationals. Now, I was an expert in one of these cases, and I'm ashamed to say I lost on this particular point, because I argued that the bit between Venezuela and Spain does not say anything about dual nationals, and it does not contain a negative nationality rule. And therefore, dual nationals are entitled, because these dual nationals are nationals of Spain, and therefore they are entitled to sue, regardless of their second Venezuelan nationality. As you mentioned, the decisions of tribunals have been conflicting. In the Serafim Garcia case, this argument prevailed, but in the other one, in which I testified, it did not, because apparently the idea that an investor cannot sue its own national state is so deeply ingrained in the minds of most people, and this, of course, comes from diplomatic protection, that the tribunal evidently thought that is a principle of law that cannot be overcome. So the phenomenon that you cannot add something that's not in the treaty was not applied here. Here, they did add the principle that a national cannot sue its own national. And a last point is the active investor requirement that you mentioned on the Standard Chartered Bank versus Tanzania. Now, this was brought up, I have a suspicion of who invented this, a well-known arbitrator whom we all know, who is very creative. And she came up with the idea, and it was a clever idea, to say, well, the treaty says the investment was made by somebody, or it was an investment by, and that indicates that the investor must have done something. And that's why a small group of tribunals came to the idea that there has to be an active investor, that it must have done something. However, that would have very far-reaching consequences. There was a case, Levy versus Peru, in which a loving father made a big donation to his daughter in the form of an investment that he had made, but she hadn't. And under this doctrine of an active investor, that she would not have been an investor because she had not made it, but her father had made it. That's obvious nonsense, of course. It doesn't make any sense. But much further reaching, if you're a passive shareholder, then you also don't make an investment you benefit from an investment, but you have not made it. And mercifully, the majority of tribunals, as far as I can see, have rejected the requirement of an active investor. I think I better stop here unless I get carried away too far.
But perhaps I'll pick up briefly on that last point. As I was one of the 3 arbitrators on the Standard Chartered Bank versus Tanzania case. And I think the case has been taken out of context in that was a case under a United Kingdom BIT. And like German BITs, UK BITs do not expressly cover indirect investment. So the question was, do you read a treaty that says nothing about indirect investment to mean the same thing as a treaty that expressly covers both direct and indirect investment? And the tribunal in the Standard Chartered case looked at the only discussion in the treaty of what the relationship needed to be between the investor and the investment for it to be covered. And that discussion in the UK treaty is the word of, OV, right? It has to be an investment of the national or company, in this case of the United Kingdom. And the conclusion of the tribunal was that in order to consider we accepted the notion that you could have an indirect investment that was covered under the treaty, but the word of suggested that there needed to be some kind of active involvement on the part of the investor. Now, that's an approach that's limited to this particular treaty where there's no discussion of indirect investment. And I think it would be a mistake to extend a similar analysis to treaties that expressly cover indirect investment. The other particularity of that case was that perhaps because of bank holding company laws, the claimant in that case expressly disclaimed that it had any role whatsoever in the investment that was at issue. And that obviously is a very specific set of facts. But anyway, that's the background, or at least my background on the Standard Chartered Bank case.
Yes, thank you very much, Bart. We are so privileged to have you on this panel, so to hear your perspective as an arbitrator who was considering this case. So thank you very much for that, and equally thanks to Joe for your presentation and to Professor Schoyer for your comments. So in the remaining time, we now finally turn to Bart, and the topic of Bart's presentation is limits to covering investors, denial of benefits, and related issues. So now I'm happy to pass the floor to you, Bart. You have about 10 minutes, if I may, so that we have about 5 minutes for final discussion and Q&A.
I can stick to those limitations. Give me just one moment because I do have a slide which I would like to share. So hopefully you can see the slide on the screen now.
We can see, yes.
Excellent. So I'm turning now to a related topic, and this is the limits that states can place on extending treaty protections to covered investors. The device that is used to implement this policy is typically a denial of benefits clause. This is a treaty provision that permits a state to exclude an investor from treaty protections, even if the investor falls squarely within the definition of investor in the treaty, as Joe has just explained. Now, a typical denial of benefits, hold on, I'm trying to get this to switch to the next screen. What's going on here? Here we go. So a typical denial of benefits clause reads like this one here, which is taken from the 2012 US model BIT. And it says, quote, a party may deny the benefits of this treaty to an investor of the other party that is an enterprise of such other party and to investments of that investor if the enterprise has no substantial business activities in the territory of the other party and persons of a non-party or of the denying party own or control the enterprise. So several points to note on this clause. First, it is discretionary. The state may deny benefits. It doesn't have to. And an act of the state is needed in order to deny benefits. It's not automatic. Second, there are two cumulative requirements that must be met for the state to deny benefits. The enterprise must have no substantial business activities in the territory of the home state. In other words, it must be a shell company without any real life. And in addition, it must be controlled by nationals either of the state hosting the investment or of a third state. Now, denial of benefits clauses raise many fascinating legal issues, but before touching on them, I would like to frame the debate in terms of policy. Now, bilateral investment treaties are typically concluded between a capital exporting state and a capital importing state. The primary interest of the capital exporting state is to protect its investment abroad, its capital abroad, and avoid a loss of national wealth. The primary interest of the capital importing state, however, is to receive capital that it needs in order to allow it to develop and stimulate its economy. Now, the main disadvantage of investment treaties from a policy perspective is the state's risk of being held liable for a treaty violation. But this risk is asymmetrical. The risk follows capital flows. The capital importing state has a much greater exposure because capital is expected to flow almost exclusively from the capital exporting state to the capital importing state. The treaty is a win-win for both parties to it because the benefits of increased capital flow to the capital importing state outweigh the risks of an increase in liability. And the benefits of increased protection for the capital of the capital exporting state outweigh the very minimal risks of liability to it. Now, what denial of benefits clauses do is to seek to address distortions that could upset the balance of policy benefits and risks. The capital importing state generally doesn't care where the money comes from, as long as it flows into its economy and helps it to grow the country. There is one exception to this, however. If the source of the capital is one of its own nationals, then the treaty may not really have been necessary for the state's own national to make those investments. For this category, the benefits of the treaty do not outweigh the risk of liability. The capital exporting state's balance of benefit and risk depends, as I've said, on the observation that risk of liability follows capital flow. Because little capital is expected to flow from the importing state to the exporting state, the capital exporting state faces relatively little risk. That balance would be upset, however, if nations of other capital exporting states were able to benefit from the treaty by incorporating holding companies in the capital importing state. The denial of benefits clause provides protection to the capital exporting state against such a distortion. So all of this is quite neat from a policy perspective. But the application of denial of benefits clauses in practice gives rise to many questions. One cluster of issues concerns the notion of substantial business activities. How substantial do those business activities need to be? Is the test different for holding companies than for operating companies? Is it enough to comply with all of the requirements for respecting the corporate form, or is more than that required? And is it sufficient to meet the tests for substance under tax or money laundering rules? Another set of issues concerns the notion of control. Does the term here have the same content that it has in defining who qualifies as an investor? Is it the kind of control exercised by shareholders that's at issue, or is it relevant to look to the nationality of company management? And what do you do about publicly traded companies who generally have objective information only about registered owners of shares, but not beneficial owners? And what do you do about companies that have no shareholder with an interest that is large enough to control it? Who is it that controls companies with no controlling shareholder? And then there is another set of issues that revolves around the temporal implications of a denial of benefits. What is the relevant time for determining control and substantial business activities? If the covered investor bought out local investors in 2015, does the fact that the company was once owned by local investors mean that it is forever exposed to a denial of benefits? What is the application in time of a denial of benefits? If the host state built a highway over part of the investor's land in 2015 and paid the investor the land's fair market value as the compensation required by the treaty, does a denial of benefits in 2021 mean that the state can recoup the difference between fair market value and the lesser compensation that would otherwise have been due under local law? What happens when a state denies benefits after its violations of the treaty were perfected and an arbitration claim brought? Is the denial prospective in effect, or is it a retroactive get out of jail free card, as in the Monopoly game? And what is the remedy for an unfounded denial of benefits? The concise terms of the denial of benefits clause that you see on the screen provide no answer to any of these questions. And therefore, I'm going to turn to my distinguished panelists to ask them what the solution might be. So, Christoph, Joe, what do you think?
May I?
Yes, sure.
I have two brief comments. The denial of benefits clause obviously is designed to counteract undesirable nationality planning. I think we agree on that. The alternative to a denial of benefits clause would be to build a restrictive definition of investor that excludes investors without economic bond to their home state. But as you said, denial of benefits is discretionary. The respondent state may, but need not invoke it. But then let's be realistic. I think the non-invocation of a denial of benefits clause is very unlikely. The litigation dynamics mandate a wise counsel or prudent counsel to invoke it. So I don't think there is much chance for an investor that he will escape the denial of benefits clause because the respondent state will not invoke it. I think the real difference in practice between a denial of benefits clause and a restrictive definition of investor that looks at economic bonds with the state of registration is the burden of proof. If the restriction to companies with real economic activities is already in the definition of investor, the claimant has the burden of proof because the claimant must show that there is jurisdiction. If in the case of a denial of benefits clause, the burden of proof is with the respondent that relies on it. I think that is the real difference between those two techniques to avoid undesirable nationality planning. And the second point I wanted to make is I think the real practical problem with denial of benefits that arise time and again before tribunal is at what point in time is the respondent obliged or allowed to invoke it. The respondent will say, well, I have no way of knowing all these investors who are active in my territory, and I have no way of knowing who is going to sue me. So how could I have invoked it in the past? So I'm invoking it now in front of the tribunal for the first time. The investor's perspective is exactly the opposite. It says, I need to have security right from the beginning of my investment. I need to know whether this will be invoked or not. If you look at decision practice of tribunals, most tribunals have sided rather with the investor on this one, particularly in Plama and in Ampal American. They said the host state should have invoked it earlier on. You can't invoke it now. There is a very new decision. I'm not sure if you've seen it. Grand Columbia Gold versus Columbia, which was decided a few months ago. I think it was in November of last year, and that sided with the host state. And I've always been very undecided. I've been very undecided about this issue. At what point must the denial of benefits be invoked? And I tend to, at the moment, at least, I'm persuaded by this particular new decision, which says the investor who has no economic bonds to its state of incorporation really is on notice that it will probably be denied standing. So there is no real expectation worthy of protection in a situation where there is a looming denial of benefits clause, and the investor must expect it's being invoked. That's it.
Thank you very much, Christoph, for your comments. I think we lost one of our co-panelists. I can't see Joe, but maybe I will then pass the floor to Bart if you have any follow-up comments or if you want to reply to anything that Christoph outlined.
Sure, just a couple of reactions. So first, as it turns out, Christoph, I'm counsel for Gran Colombia, and so I'm actually quite familiar with the decision that you just referred to. And the tribunal in that case, of course, quite rightly found that there were substantial business activities in Canada and dismissed the denial of benefits objection. As part of the tribunal's reasoning, it did take a view that there was no requirement in the treaty for the state to deny benefits at any specific point in time. And that was not actually a point that was in dispute. The tribunal didn't actually address the argument that was advanced by the investor in that case, which was that while the state can deny benefits whenever it wishes to, in an ICSID case, it can't deny benefits after consent has been perfected and have that divest the tribunal of jurisdiction because of the clear terms of the ICSID Convention. And in fact, denial of benefits, the investor argued in that case, are obviously prospective in effect and not retroactive in effect. But as I said, the tribunal did not address that particular issue.
Thank
Joe,
you
you're
very
back.
much. Yeah, Joe, welcome back.
Forgive me, my main computer just died on me, but fortunately I have the backup thanks to Alexander's guidance.
Okay, great to have you back. Do you have any comments, by the way?
Well, no, I mean, I think it's kind of, Professor Schoyer obviously, I think, raised some very interesting points. And ultimately, I think it is very difficult for an investor to rely on the fact that it won't be invoked for the very reasons that I think Bart so eloquently listed. There are so many questions and so many uncertainties, I think, that are associated with that. It's very, very difficult. It's encouraging, I think, again, that there are tribunals seem to be leaning in favor of the investor if you're looking at it from the investor's perspective. But I can see scenarios where it's clearly there is a pushback, I think, against investors looking to effectively benefit from in circumstances where the host country doesn't seem to obtain a significant benefit. And I think that's interesting. One of the few words that is in there is obviously the substantial operations, which, as Bart says, is not defined, and that will be different for different jurisdictions. Obviously, the employing 100 people in one jurisdiction may actually be a significant operation for that and have significant impact in that local economy than in a much bigger jurisdiction. So I think it's one of those ones that I think you have to tread extremely carefully with, and it's very difficult to be able to give any kind of concrete advice other than, as I say, the consensus seems to be leaning more towards the investor in that scenario.
Yeah, thank you very much, Joe. I have to say that we are a bit behind our schedule. And since we don't have any questions from the audience to any of the speakers, unless you object and unless you have any further comments to make, I would suggest that we wrap up our discussion. And with that, I would like to thank greatly our speakers for finding the time and for providing your presentations. That was very exciting and I believe that was very helpful for our audience. And finally, I would also like to speak the organizers, the Russian Arbitration Center, for providing the platform for such a great event. And I would like to wish all the participants of FIAMC Pre-Moot best of luck tomorrow and on Sunday during the rounds. And also, of course, best of luck during global rounds in Frankfurt in the beginning of March. That's a great educational opportunity. And I myself, as a former participant of FIAMC Moot Court, probably would say that the best moot court among all of those available. But that's, of course, my personal opinion. So thank you very much. And have a nice evening, everyone. A nice weekend.
Thank you,
Thank you.
Thank you. Thank you.
Good luck, everyone.
Bye-bye.
Bye.
Bye.